basically we believe that's the basic.
That's right. You know, only that to add that the proper name of appeal is a notice of preliminary objection. So that we need notice. If they intend to bring a notice in within, let them not throw it within the application because we shall not have notice or rather sufficient notice to deal with it. But as be that as it may, let me proceed with our application. You know, as is already indicated, our application is dated 16th of June 2025, the year of the Lord. The substantive prayer sought is prayer B on the face of the application. That prayer is that the respondent before court be remanded at the Langat police station or any other police station within the Republic of Kenya and the reason being, and this is the justification, that it will enable the applicant herein through the Independent Policing Oversight Authority to continue and conclude investigations in respect of the facts, the basis of the arrest of the respondent. Our application is based on both law and facts. And to be more specific, Articles 24, 29, 49, of the Constitution and Section 36, capital A, of the Criminal Procedure Code. We will also make references to the decision of the High Court of Kenya at Uhuru, Honorable Justice Joy Ngugi, a judge I hold so highly, in the decision of Sudi Oscar Kichumba versus Republic, and this is Criminal Revision number 208 of 2020. Fundamentally, that decision of the learned Justice Ngugi, as he then was, because he now sits at the Court of Appeal, cites and makes reference to the decision of the High Court of Kenya at Milimani, delivered 4 years before it by the learned Justice Luka Kimaru, as he then was as well, because he equally sits at the Court of Appeal, in Michael Rotich versus Republic. And we preempt that the defense are likely to run away with Michael Rotich, so we are going to hit hard on it before they get a chance. In summary, what we are requesting this court to do is to issue an order for what the Constitution calls detention continuing. So that the respondent remains in custody, that's the common name that we call it custodial orders, for purposes of completion of investigations. Cognizant of the limited jurisdiction of this court under Section 8, subsection 2 of the Magistrates Court Act 2015, our references to Article 29 is only in passing and for purposes of laying basis that every person I am paraphrasing, every person has the right to freedom and security of their person, including the respondent. Your Honor, in further laying of the basis, that Article 24 of the Constitution allows for limitation of rights under the Constitution, save for the rights under Article 25 thereof. So that while we acknowledge that the respondent has a right to freedom, right to security of his person, and a right to liberty, all those rights fall outside Article 25 and can be reasonably limited. Where there is justification, and where, Your Honor, it is established that the kind of limitation we are seeking in the nature of detention continuing is the least restrictive measure. So that, Your Honor, once we have established, as we have, that Article 24 permits the limitation of the right to freedom and liberty, then we shall, through my learned singer, take the court through our affidavit to establish the justification. But, Your Honor, Article 49(1)(f)(1) sorry, that is 49(1)(g), Your Honor, I'm sorry. And if you allow me to read, an arrested person has the right at the first court appearance to be charged or, and this is important, as informed of the reason for the detention continuing or to be released. And so out of the three available options under Article 49(1)(g), we have come to court to seek detention continuing. Your Honor, with that legal basis, allow me to make a reference to the learned Joel Ngugi J, as he then was, in Sudi Oscar Kipchumba,
the right of making submissions. We have made our submissions. So that once they have done this, they will surrender this for cross-examination and they'll have no right. Procedurally, it is the deponent to be put on the dock, and the deponent is cross-examined. The respondent's lawyers submit. It's the reverse. And that's what I'm asking. Is my old JV abdicating the role?
My answer was just lay the basis so that once the deponent comes to the door, then we can proceed from there. So let me just finish with your basis. I believe it's more or less an open statement.
He has done an opening statement.
Yes,
We literally can be doing an opening statement to lay the basis and counter what has been said, because he is doing actually an opening statement. We will also be seeking that we also put an opening statement and before the court.
So
That's all.
Sorry, Your Honor, I do not understand the basis of that argument, because we are arguing our application with both facts and the law. So I'm doing the law, then my colleague will do the facts. It's the same thing if we started with the facts. So I'm almost done with the law. But sometimes it does that to take me off-road, and he knows I never get off-road. Your Honor, I was inviting the court to paragraph 24 of the very erudite decision of learned Justice Joel Ngugi, which sets the test required for the grant of the order of detention continuing, which my other colleagues prefer to call custodial orders. And it says, at paragraph 24, if you permit me to read, so even while accepting that the text of Article 49(1)(f) may, in certain circumstances and contexts, and we submit like this one, comprehend a situation where a person is presented before a court without being formally charged and is thereby informed of the reasons for his continued detention through the state's application, like ours, to have him so held, the state must satisfy a double test. A, first, the state must persuade the court that it is acting in absolute good faith and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. So that you are, through the factual matrix, we are going to establish exceptional circumstances. And B, this is the second part of the test. Second, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interest. Now, this is very interesting. Quadruple interests present in a potential criminal trial. There is a potential criminal trial, and this is the quadruple interest. Number one, the rights of the accused individual, in this case the respondent, who is likely to be charged in a potential criminal trial. Number two, the public interest, order, and security. You know, it is not in doubt that this is one of the great matters of the greatest public interest in the country at the moment. Number three, the needs to preserve the integrity of the administration of justice. We will discuss that in a minute. And finally, and the interests of victims of crime where appropriate. And the court, in cracking its head about it, continues to say, by virtue of Articles 21(1) and 259 of the Constitution, the court must act to aggrandize, not diminish, the personal liberties of arrested individuals in line with the other three interests. But importantly, differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail while balancing all factors within the complex permutation presented by these quadruple interests, and without refining or essentializing any. You know, I dare say kizungu kubwa. Having highlighted those two texts, Your Honor, the state is acting in utmost absolute good faith to have presented the respondent within a reasonable time before court. Other than in the police cells, through the affidavit before you, the respondent has been informed, one, of the reason of his arrest, and two, of the reason why the state seeks to continue to detain him. That is a show of utmost good faith. You know, in insurance law, it's called uberimai fidei. That good faith is furthered by the fact, as my learned senior will tell you in the facts, or rather in the affidavit, that there has been some investigations ongoing, and that we just need a limited period within which to complete those investigations. And finally, from my part, in compliance with the need provided for under Article 24 of the Constitution, that the limited detention of the respondent is the least restrictive measure we could adopt to protect both the interests of the respondent, the victim's interest, and as equally important, the interests of the public to ensure safety and security. You know, with that legal background, I invite my learned senior, Mr. Jalson Makori, to take you through the factual matrix in the affidavit. I am also obliged unless there is a question. Thank you.
Your Honor Makori. Your Honor, we are referring to the affidavit by one Abdurrahman Jibri. Abdurrahman Jibri, dated the 16th of June 2025. It is an affidavit in support of the notice of motion, dated the 16th of June 2025. Your Honor, I'll only take you, I'll only highlight the paragraphs that are in the affidavit. Paragraph 6 sets out the background of the investigation. And these are the preliminary investigations by IPOA, which reveals in paragraph 6A to E, 6A to E, that is on the 4th of June 2025, the DCI received a complaint from the DIG of police, Mr. Langat, alleging he suffered continued false and malicious publications on an X account, formerly Twitter, with the username Pixel Pioneer, and requested investigations with a view to establish the person and motive behind it. Your Honor, A to E establishes the grounds in which the investigations were mounted. It is at paragraph 6D. On the 7th of June, the DCI team went to Linda Center in Homa Bay County and arrested the deceased at around 2:30 p.m. And they took him to Mawengo police station, placed him in custody with the OB number 10/7/6/2025. That is 10/7/6/2025. Then at around 3:54 p.m., the deceased was booked out under OB number 11/7/6/2025 and escorted to Nairobi, where he was booked at Central Police Station under OB 136/7/6/2025 at 9:32 p.m. Your Honor, we have annexed to paragraph 6E the OB extract, that is AJ1, indicating the time that the deceased was booked at Central Police Station. Paragraph 7, Your Honor, the respondent was arrested. And this is something that would wish the court to take notice. The respondent was arrested on the 13th June 2025 at 18 05 hours, that is 6:05, which was on a Friday. The respondent in paragraph 8 was informed of the reasons of the arrest and for which the reasons and of the offense that is being investigated. That is under paragraph 8. Your Honor, in paragraph 10, now we are coming to the reasons why we want to continue holding the respondent. The respondent is the custodian of the station records, being an OCS, officer commanding station, and the surveillance system, the CCTV. And this is at the material time under the investigations.
You are still a master. What will be the respondent is telling this?
Your Honor,
The information the DPP is giving, it is not them who depend. It is the one who depend who should be giving us those paragraphs in paragraph 4. Then the DPP can buttress their submissions based on that. Right now, the DPP is turning himself into a witness. And we cannot cross-examine the DPP. It is fair and just. The witness who depend takes us through is unjust.
Your Honor, as I said that I'll only highlight a few paragraphs which I wanted the court to take note of. Because
it's a dicey situation because
yes,
you're literally taking us through the but I'll leave your own strategy
yes,
on how to do the application.
the defense
But don't go into details
yes,
of the evidence. I'm sure the defendant will have a chance.
yes.
So I'll leave you to proceed, but I don't go too much into the position.
No, Your Honor, I'm only highlighting some paragraphs. I'm not going through the whole affidavit because we have already indicated that they want the deponent on the dock for cross-examination. Yes, Your Honor, what we are... Yes, at the CCTV, yes, we said paragraph 10, the respondent is the custodian of the station records and the surveillance system, that is the CCTV, that is under investigation. Yes, investigations reveal that under paragraph 11, that the respondent, together with others who are not before court, hired a technician to interfere with the CCTV system at the Central Police Station in a bid to tamper and interfere with the subsequent investigation. Your Honor, we are highlighting what so far we have done insofar as investigations are undergoing. So there is still some investigations which we need, and that is the reason why we are asking for continuing detainment of the respondent, because the respondent's mobile phone has been detained. And it is subject to investigation. Your Honor, there are also witnesses who are yet to be investigated and statements taken from them also witnesses police officers who are on duty at Central Police Station on that night. Your Honor, given that the respondent is the OCS, we are saying that there's a likelihood that he may interfere with the investigations. Your Honor, we'll be seeking the 21 days. To continue holding the respondent. And in addition to the 21 days, Your Honor, we'll be seeking an order that we access the forms of potential witnesses, the police officers who are on duty, and any other person who was at the vicinity at Central Police Station. And this, Your Honor, we are relying upon paragraph 17 and 18, where we have shown in the paragraphs, we have demonstrated that there is already interference which has already been done. With that, Your Honor, we will be inviting the deponent, the doc, for the cross-examination.
You can testify from here. It's comfortable there where is. Your Honor, we'll be seeking that these are standing to an opening statement. They will be allowed to put a 3 minutes opening statement.
So let me finish.
But,
And then,
much.
I swear by the name of the Almighty God, the evidence I shall give before this court, touching the matter in question, shall be the truth, the whole truth, and nothing but the truth. So help me God.